The three key tips for trademark licensing are, firstly, you need to have total clarity over two things throughout the whole process, I would say. The first of them is having clarity over what your commercial goals are and what you're trying to achieve, both for licensor and licensee. And the second one is having a way of expressing that in a legally binding and effective way. Now, the first one really ultimately boils down to making sure you retain brand value and equity. That, again, important for both licensor and licensee. And the second point really turns on having attention to detail throughout the process and giving it the time that it needs. And generally, on the whole, most of the disputes and litigation that comes out of trademark licensing is as a result of there not being sufficient time or sufficient attention to detail being given to that when needed. The second point is really recognition that one size doesn't fit all for all situations worldwide. This is particularly true because the procedures in different jurisdictions do vary. To pick up just two, for example, in the USA, it is imperative that you have effective quality control provisions in the license and you implement them. If you don't, you have what's called a naked license. That's treated as amounting to abandoning your trademark, and it will then be invalidated. And yet, quality control provisions are not definitely required in the European Union, for example. For another situation would be in Russia, where if you're even with an intra-group license, you've got to have it in writing and signed by the licensor. And in particular, it must be recorded at the registry. If you don't record it at the registry, essentially your trademark registration can be invalidated. So both are very serious scenarios and have terrible implications if you haven't got that right. And the third key tip is, if you do want to cut corners and have a really short form license, which might work for you, particularly, for example, in one jurisdiction, it's really important you know what the situation is in default. In other words, if there's nothing in the license at all. This relates to issues such as insolvency, the duration of the license, whether the licensee can sue, for example, and in particular the termination provisions. So as long as you understand those, you can get away with possibly having a short form license. The templates that do exist on the internet, and I know I've seen many of them, may well be appropriate for your licensing situation. I mean, the first thing to bear in mind, of course, is that such a template will be someone's work and therefore a copyright-protected work. You can't necessarily use it, but many of them are there and actually say that you can use them for free. The only problem is you do need to make sure that it suits your needs. And those sorts of templates don't necessarily always do so. Different licensing scenarios require different drafting requirements. Just by way of example, brand or line extensions may often be moving into areas that the licensor hasn't previously had protected. That means the burden and the costs of securing that protection and doing the brand clearances is something that may fall upon the licensee potentially. Likewise, for geographic extensions, when you're moving into new countries and territories, there you may well find that the rights haven't yet been registered. Again, who's going to cover the costs of those? Probably the licensor will own those rights, but again, who covers the costs, who covers the clearance costs, and in addition, you've got issues of which currency you're going to pay in, exchange rate fluctuations, withholding taxes. All of those sort of points would then need to be addressed in an international license in new territories. And a final one would be, for example, in franchising type agreements, where the burden of marketing will fall on the licensor typically. And yet in merchandising type agreements, often that's something particularly put on an exclusive licensee. Licensing characters, for example, cartoon characters, do give rise to some special considerations. The main one particularly is that characters can last a very long time. I mean, we look at Mickey Mouse, the Beano characters, they've been around for decades. And those sorts of rights also evolve over time. So it's very important when you're taking a license or granting a license over them that you really are specifying clearly which particular version of the character you're relying on, and then the multiple rights that could come into play. The copyright, the design rights, and the trademark rights all need to be looked at and licensed and listed very carefully in those licenses. The evolution of that character over time is also important because often it will evolve as it goes into a new medium, a film version, a TV version, addressing possibly different audiences. They may well want to adapt it, but then you've got to specify very clearly who gets the rights in the new version, the merchandising, maybe there's different splits of merchandising. That also particularly arises if, for example, you go from a cartoon character into a real actor. I mean, the classic would be Batman, but it may happen in many other types of scenarios, Superman. And so essentially, once it then goes into a human character, you've got a totally different form again for merchandising. And so those sorts of merchandising royalty revenues need to be split appropriately. You know, does it go to the TV or film production company? Does it go to the licensor? How is the split made? Those are the sorts of things that tend to require special attention in trademark licenses.